Hi, good afternoon, everyone. Can you hear me? Dashita, you can hear me, I hope.
Yeah, I can.
Perfect. So, good afternoon, everyone, and thank you for joining me. Happy Eid to everyone. Before we begin, please disable your video and mute yourselves to optimize sound and video quality for everyone. And allow me to please introduce Dashita. Ms. Dashita Turaraja was admitted as an advocate and solicitor of the Supreme Court of Singapore in 2017, where she earned her Juris Doctorate, and she earned her Juris Doctorate from the Singapore Management University. Dashita has extensive experience in the payments and e-commerce industry. As part of her work as a lawyer, she advises tech, payment processing, trade financing companies on commercial, licensing, and cross-border merger and acquisition deals. She also deals with financial services regulatory matters involving banks, fintech companies, and other financial institutions. A fun factoid is that I've known Dashita since we were, I would say, more than 10 years. So she's a very good friend of mine, and I'm very happy that she's here to join us at SheTrades Commonwealth. So with that, I'll pass the presentation on to you, Dashita.
Okay, thanks, Edison, for the introduction. Hi, everyone. So I'm Dashita, and I'm actually very excited to be a part of this webinar series in collaboration with SheTrades. As you may already know, I'll be speaking on several topics over the course of the next few weeks. And the first topic that I will be covering is on legal considerations for websites and apps. This topic itself branches out into several areas. You have terms of use, terms and conditions, and privacy policies, which are all important legal documentation for your business if you have a website or an app. So for today, I will be introducing you to the first legal documentation, terms of use. And in 2 weeks' time, I will continue with part 2, which will be on how to draft your terms and conditions and privacy policies. All right, so before I start, I'd just like to set some house rules for the webinar. The slides for this webinar will not be shared to you, but not to worry. This webinar is being recorded and that will be shared with you sometime after today. Also, some of the content in these slides may be a bit difficult for some of you. There's going to be a couple of legal terms, a couple technical terms, and if at any time you feel that you have any questions on the content, or if you need me to slow down or explain something a bit more, just feel free to provide your questions in the chat box. And at the end of this presentation, Edison and I will go through them and try to answer as many of the questions that you have. Okay, so to get started on this presentation proper, what is a term of use? So let me give you a couple of examples. If you're on Facebook's website and when you register for an account, you might have seen somewhere along at the sign up button, near the sign up button, you'd see something that says terms also. When you have to register an account, you have to agree to the terms of Facebook, right? So that is an example of terms of use. And for example, if you're on Gmail and you want to create a brand new account, you will also see here, there's a terms hyperlink, where when you create a Gmail account, you are also agreeing to Google's terms. This is one of my friend's fashion e-commerce website, and if you look at the bottom of this picture itself, you will see that there's a reference to the fashion shop's terms of service. So you can see that the phrase terms of service is not actually very different from terms of use. They're sort of used interchangeably depending on the type of service they're offering or the type of product they're trying to sell. Okay, so why do we need terms of use for your website, for your business or business's website or app? First off, the terms of use is actually a contract between your company and a user who visits or uses your company's website or app. Generally, these terms of use are drafted from the perspective of the company, your company, and it's rarely negotiated with the user. So that is why, for example, if you want to use Facebook, right, you will need to agree to their terms of use. And you as a user don't really have any say, any bargaining power in amending or asking for any other changes to the terms of use. You just have to simply accept and agree to it. So it's the first of why it's important is because it's a contract. Secondly, terms of use is very important because it sets out a bunch of rules which govern how a user can access and use your company's website or app. So you can have language in your terms of use which prohibits illegal or undesirable behavior amongst users who use your websites or applications. Thirdly, terms of use is also important to help to minimize your business's liability when users access and use your website or app. And last but not least, it helps to also protect intellectual property because your terms of use will have certain language that helps protect the intellectual property that's contained on your website or app. And here, intellectual property means, for example, the copyright content on your website, your logos on your website or app, which are trademarked, for example, your photos that you put on your website. These are all intellectual property that you want to protect. Okay, so at this point, I'd just like to make it clear that you will come across in very many websites or apps, something called terms of service. Earlier we saw terms, and they are all sort of used interchangeably, and they're not very different in terms of the content of the document itself. So why do some companies use terms of service instead of terms of use? They use terms of service, for example, if they're providing a service. So service providers like maybe a social media site, WhatsApp, if you're providing a ride-sharing app like Uber or so, right? You're providing a service, then you would rather use the terms of service instead of terms of use. Okay, so now that you understand that terms of use is a contract or an agreement, right, between a user and a company. But if you normally want to enter into a contract, I would sign a contract and then I'll give it to you and you would sign the contract, and that will make it a legally binding and enforceable contract. But how do you do this with terms of use on a website or an app? Because if I'm on the internet and if I have a website or an app, right, I can't get every user that visits my website to sign a legal document and like post it and then get them to sign it, right? I can't get that to be done. So how can I make sure that each and every user enters into a legally binding contract with me? And how do I make sure that my terms of use are legally binding? So before I explain how to make it legally binding, I'd just like to explain what are the elements that you need to have to form a legally binding contract. So I'm not sure if many of you may know this. I hope you do. But if not, I'll just explain it very briefly. To form a contract, you usually need to have an offer from someone, acceptance of that offer, consideration in the form of payment or exchange of benefit, intention to create legal relations, and you must obviously not be forced to enter into the contract. So I'm going to focus a bit more on the first two elements today, which is offer and acceptance, which are very important, especially with terms of use or any of these kind of documents. So how do you make sure that your terms of use is binding on users? First, you need to make sure that you offer or you present your terms of use to a user in the form of a hyperlink or otherwise. And next, you need to make sure that your user agrees or accepts to use your website or your app under such terms of use. So look here on the right side, if you see Facebook and how they've done it, right? Before a user can use Facebook, the user will need to click on the sign up button or like an I accept button to indicate that they have read the terms of use and they agree to it. So this is one way you can do it. I will give you a couple of other examples as well. So if you look on the left, right, you will see that you can place your terms of use in this type of scroll down fashion with the checkbox at the bottom for the user to click and agree. Or on the right, you can do it in a different fashion where you set out in the hyperlink your terms of use, and the user can click on the hyperlink to read the terms of use, or if you're lazy, then they don't. But as long as they click I agree, that is some form of active acceptance of these terms of use. So you have the offer and you have acceptance, And that already makes it somewhat a legally binding contract. So I'd just like to take this moment to explain that having to click a I accept concept is usually probably the best way to do so. So we have this, clicking on this I accept to this terms. So it's the best way to do to make sure that this document or this terms of use that you have is legally binding, because you make sure obviously that the user has read and accepted the terms, and that makes it legally binding. But sometimes this might not be the best way, right? Because if I am a user and I visit your app or your website, I'm going to lose interest if I see this kind of a screen kind of blocking or hindering me from quickly accessing the content on your website or your app. And this will definitely reduce my user experience. So if you don't want to maybe lose customers or users who are a bit more fidgety and don't want to click I accept or read the terms of use, one way to do this is to have in place some language in your terms of use that states, okay, because you are browsing our website or app, you are deemed or assumed to have accepted our terms. So that's another way you can do it, sort of like a deemed acceptance. But that's it. The best way, of course, to still make sure that you have a legally binding contract with the user is to use this click and accept concept. Okay, so far we've covered what is a terms of use. We've covered why do we need a terms of use. And for now, this part of this webinar, I'm going to talk about what should you have in your terms of use. And I'll be going through some of the important clauses that you should consider having in your terms of use. Okay, so the first one that I've put out here is known as an acceptance clause. And okay, and sorry, just looking at the chat as I go. Okay, so when you have an acceptance clause such as this, what you want to make sure is that if you read the highlighted portion here, it says that by using or clicking to accept or agree to the terms of use, you accept and agree to be bound and abide by these terms of use. And if you do not want to use these terms of use, if you do not want to agree to these terms of use, you must not use or access the website. So this is a very helpful clause and you should have it at the start of your terms of use, because it sets out very clearly that you want to make this document legally binding on the user. And as long as the user has clicked on the I accept button or continues to use this website or app, they have actually agreed to the terms of use. So that's very easy and very simple. May I please ask everyone to try to keep maybe themselves on mute if possible, because it will help quite a bit here on my end, I guess. Okay. All right. So moving on to the next slide, right? We have another important clause here that you want to have in your terms of use, known as an acceptable and prohibited use clause. So if you look here, it states that you may only use the website or app for lawful purposes, but a user cannot use this website or app for prohibited uses. And there's a list here that you have. A user can't use it in breach of local laws. They cannot upload content that is illegal, harmful, or does not comply with your company's content standards. You cannot use the website or app to upload any viruses, Trojan horses, or do anything that could affect the operation of your software or hardware. You cannot reproduce or copy any of the materials on your website without your written consent. You cannot send spam or junk materials, and so on and so forth. So this is just like, a generic list of prohibited uses, but you can use this to sort of build a list of acceptable and prohibited users to suit the type of business and customer or user base that you have. So I'd like to also bring your attention to B, right? So B here refers to our company's content standards. What does this mean? So content standards essentially would apply to your business if you have, for example, if you have a business that requires you to comment or rate on products or upload pictures or documents and materials, then you want to make sure that you come up with some sort of content standards as to what a user can post or upload. So for example, you want to state that any content uploaded cannot be offensive, hateful, promote violence, discrimination, or be pornographic, for example. So this is what you want to try and develop as you go along in trying to create your content standards if you need, depending on your type of business model. Okay, we now go on to a new clause. This is also quite important. It's about ownership of IP and the license to use the IP. So what you want to have in your terms of use is a clause that talks about your company's ownership of intellectual property and ability to grant licenses. So in about a month's time, I will be giving another webinar about intellectual property and what that means and stuff like that. But for the purposes of today, I'll just give a very brief understanding, of what, for those who might not know what intellectual property is. So intellectual property here refers to intangible property, property that is created by the human mind, human intellect, human ideas. So some examples could be copyright, trademarks, designs, domain names, your logos, your trade names, your trade secrets and patents. So in an app or a website, right, the source code that you use to build your website or your app is a type of copyright. The content on your website is also a type of copyright. And another example could be if your website has a logo or your app has a specific logo, that is a type of trademark. Obviously, this depends on whether you register them or not to get them protected, but that's for the other seminar. So having a clause that states we own all copyright, trademarks, domain names, blah, 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 including our software, future updates, upgrades, and new versions of our software associated with our website, that itself protects your company's intellectual property. Because if you look at the next line, it says, you shall not use our intellectual property rights unless you have our prior written consent. Okay, so another related clause is one that grants a license to use the website or the app. So let me try to explain this. For example, if you are Uber and you have just developed an app that allows people to find and share car rides, then you will want to have a clause in your terms of use which grants users a limited right to use your Uber technology so that users can find car rides. And if you don't, right, then you haven't actually given them the right to use your intellectual property or your technology. So this is why the second paragraph has this clause that says, in order to operate or provide our services through our website, here you can use app or website, we grant you a limited, revocable, non-exclusive, non-sublicensable, and non-transferable license to use our website. And if you look at the next line, it says, no license or rights are granted to you by implication or otherwise. Okay, so this is almost a tongue twister in itself, that whole line, right? So let me try to explain what each of these words mean. So, okay, so limited here means that there are some restrictions on your license. If I'm Uber, I would want to limit the license to use my technology solely to you as a user to find car rides and not anything more. I don't want you to be able to use it to develop your own technology or anything else. So my license to you and why I would let you use my technology is solely for you to find car rides in my app. So that's what limited means. Revocable here means that the license can be revoked or it can be terminated at any point in time. Non-exclusive means that the license is granted to one use, is not granted to one user only. That means it's granted to all users in essence. Non-sublicensable means that a user cannot sublicense the license that's provided to a user. Okay, that's a bit of a, let me explain that better. So, which means you don't really have a right to grant another person Uber's license to you. So you can't, allow someone else to use your license. That person himself will need to sign up with Uber to get a license to use that technology. Okay, the last one is non-transferable. So non-transferable means that the user cannot transfer the license that they have to someone else. So by doing all this, right, you're trying to restrict the license that you have granted to a user to use your technology. So this is why this clause is important, and probably one of the more important ones as well, because you want to protect your IP and give users the right to use just the right amount of your IP and for specific purposes only. Okay, another clause that you want to have in your terms of use is a third-party terms of use clause. So this clause here helps to explain to users that there are other third parties which users may interact with when they use your website or app. So for example, if you have an e-commerce website, you may have a payment page, right? An API plugin that is interacting with your users each time that they want to pay for a product that they buy on your website. So for these third parties, you want to have a clause which explains that your company or business is not responsible for these third parties that interact with users. So you want to say something like, we are not responsible for, and we do not endorse, support, or guarantee the lawfulness, suitability, efficacy, safety, or quality of these third-party products. The purpose of this, right, is to make sure that you and your business is not liable for any user's relationship or interaction with a third party. And this helps you protect and keep your business separate from third-party service providers that work with you. And why is this important? Let me try to give an example. If you have a third-party service provider that suddenly has a data breach or has been hacked or is shut down for some reason by government or regulators, then whatever interactions that the users had with the third party is separate from the interactions the users had with you. And the users should not be blaming you for that, for the quality or suitability or the safety of that third party service. Okay, so this is another clause that you want to have that's quite important. Next, there is also this clause on monitoring, enforcement, and termination. So generally, if a user does breach your terms of use, you want to have some sort of enforcement mechanism to take action against them, against the user. So if you see this clause, right, once a user has breached a term, the company can take these few actions such as issuing a warning, terminating or suspending the user's access to all or some part of the website or app, immediately removing any harmful content from the website or app, taking legal proceedings against the user, or even reporting the user for any harmful acts, maybe to some police or government agencies. So these are some generic terms of course here. So for you, think about maybe how well you want to customize this to suit your business, or how best you want to deal with your customers or users who access and use your website. Sometimes you don't want to be too harsh, right? You don't want to immediately remove them. So maybe you want to give them like 3 warnings before you terminate them or remove them. So you can sort of draft this to suit your business. Okay, at this point in time, I hope you're not too overwhelmed with the different clauses and how they're important. So I think a lot of you probably already sharing, your questions and so. So if you need me to explain any of these clauses, concepts, or anything, just continue to post your questions in the comments. Okay, moving on to the next clause, we have a reservation of rights clause. So let's take a read here. We reserve the right to withdraw or amend this website and any service or material that we provide on the website in our sole discretion without notice. So Generally, a reservation of rights clause allows you to make changes to a website, withdraw certain functions that were previously available on your website, or even restrict access to certain parts of the website without incurring liability. So let me try to give you an example. If you have a website that allows people to watch 5 free funny cat videos each day, but now you decide to change that to 2 free funny cat videos, this is definitely a change, right? Or a withdrawal of a function that was previously available. And users may not be happy about this because they're like, hey, I'm paying a subscription fee of $10 to watch 5 free funny cat videos, but now I can only watch 2. So how is this possible, right? So by having a reservation of rights clause in the end, this leaves it up to you to maybe if you feel that your business can't afford to give 5 free funny cat videos, then you should be allowed to make these minor changes to your business model. And if you draft your clause well enough to inform users that you have the right to make such changes, then they've already been put on notice. And because they agreed and accepted to this terms of use, that allows you to make these changes. Okay, now we look at the second paragraph here. We have the right to disable any account, username, password, whether chosen by you or provided by us. So here again, it's another reservation of right clause in a way. So, and if it's drafted right, it basically allows you as your business to restrict certain users from accessing your website or app. If, for example, maybe they're posting illegal content and you want to disable them. Okay, another important clause here that I would like to talk about is an amendments clause. So amendments clause here helps to explain to users that your company may actually revise the terms of use from time to time by continuing to use and by continuing to use the website or app, the user actually agrees and accepts these new changes. So I think if you remember, we talked about this earlier in the earlier slides. How do we make a terms of use a legally binding contract? And we also talked that we want to try to get users to click on the I accept button of the terms of use. So when there are substantial changes to your terms of use, it might be useful to have a new notification to users by way of email that says, hey users, we have made XYZ changes to our terms, and we now have a new I accept button that we want users to click and accept to agree to the revised or modified terms of use. So that's the point of a clause like this. Okay, moving on, I think this is probably one of the most important clauses to have in your terms of use. It's a disclaimer and exclusion of liability clause. So generally having such a clause helps to limit your liability for any loss, damage, expenses, costs, or anything else that's arising from the use of the website or app by a user. But of course, in the end of the day, how much liability you can exclude or limit depends on the laws of your country. So for example, in Singapore, you cannot exclude liability for death. And maybe in other countries, you may have certain restrictions. So here, it's pretty much depends on trying to work with your legal advisors to see how you can draft this to limit your liability for your website or your app. Another example could be, for example, if your website goes down for a few days, maybe your server is unavailable and users are not able to access the website, then you want to have this in your terms of use to say, like, we're not liable for any loss or damage in terms of the reliability of our website or the security of our website, stuff like that. Okay, and we are down to the last one here on a governing law and jurisdictions clause. So here, if there is a legal dispute, whether maybe arising from a user wanting to make a claim against your website or app, or if your company wants to sue a user for any reason, the law that would govern these terms of use, which is also known as a contract, right, is the laws of the country that you choose and the courts that you choose. So if you look here, it says all matters relating to the website and the terms of use and any dispute or claim arising therefrom or related thereto shall be governed and construed in accordance with the laws of country X. So here, if you have your business located in Ghana or Bangladesh, then you want to state your, that it's based on the laws of that country. And in the second paragraph, you see that any legal suit, action, or proceeding arising out of or related to these terms of use or website shall be instituted exclusively in the courts of the same country. So if you're based somewhere, try to put that country as the place where you want to exercise jurisdiction. So there are other dispute resolution mechanisms. I'm not sure if you might have heard of arbitration or mediation to resolve your disputes. But in the end of the day, this is actually a decision that you'll probably need to take as to see whether, does arbitration work the best for you, courts or mediation, and that's something you can decide with your legal advisors. Okay, so what I've covered so far are some generic and important terms that you want to consider when you're drafting your website or app terms of use. Now I'm going to use WhatsApp as a case study. WhatsApp's terms of service, and if you remember that I mentioned earlier, the phrase terms of service can be used interchangeably with the terms of use, as they're pretty much one and the same. And why does WhatsApp call it a terms of service? Because they're providing a messaging service. But you'll see in this case study that the clauses are quite similar, and we can then see how they've applied it accordingly. So give me a second, I'll change this screen sharing. Okay, so everyone can see this slide, the terms here, right? Okay, so you can see how WhatsApp does it in the terms of service. First, they have this line that says last modified January 8, 2020, 28, 2020, and they've also put the archive version. So if you click on, it's a hyperlink, right? So if you set out some of these archived versions, and if you also set out the date of the last modification, this is a very good way to structure your terms of service or terms of use, because it allows customers or users to know if this terms of service has been recently amended, how many versions, and they can then identify what are the changes here. So if you look at this highlighted portion here, you will see that you agree to use our terms of service by installing, accessing, or using our app, services, features, software, or website. Here, this is essentially the user acceptance clause that I talked about earlier. So as long as the user installs WhatsApp, they've agreed to the terms. If they decide to access or use the app, they've also agreed to the terms. And if they use WhatsApp web, that's also agreeing to the terms. Okay. Here about their services, WhatsApp actually sets out an age. They say that you need to be at least 13 years old in order to use WhatsApp services, or such age that you require that you're authorized to use our services. So why do you have such a clause? Because for minors, they're not usually given the right to enter into a contract until they are an adult or after a certain age. So any minor that's below that particular age, which is different from country to country, we want to make sure that the parent or guardian must agree to the terms on their behalf. So this is something you want to also think about including as some of the other minor points. Then we come across this huge chunk here, right, of legal and acceptable uses. So this is essentially the clause I was talking about, where you set out what are your acceptable uses of WhatsApp services and the prohibited uses. And this has to be customized based on your business, the type of services that you offer, or the products that you offer. So here you can see that they say here, you will not use our services in any way that violates, misappropriates, or infringes the rights of WhatsApp, our users, including privacy, publicity, stuff like that. They even state that, you know, you must not use our services in a way that is illegal, obscene, defamatory, threatening, intimidating, racially or ethnically offensive. And you know, specifically WhatsApp, they want to make sure that there's no falsehoods, misrepresentations, or misleading statements. You don't want to impersonate someone on WhatsApp, and stuff like that. So you have all these acceptable and prohibited users, and you want to make sure that this is you sort of customize it really based on what you're providing and what you think are some things you don't want to have users doing. For WhatsApp, they actually included like another whole section here on what users must not do. And these were, if you can see here, it says you must not reverse engineer, modify, or create derivative works from our services or our codes. You must not transmit viruses or harmful computer code. We saw this earlier in our slides as well, and so on and so forth. So if you look at all these, they're pretty much focused a bit more on preventing a user from disabling WhatsApp security or copying their technology. So technically, you can also keep this together in the same paragraph if you want. You don't have to really split it up in this way, but it's pretty much just style and the way you want to do it. Then they also have a third-party services clause, but you will see that the third-party services clause is slightly different. What they've stated here is that when you access their services, a user will be interacting with third-party websites, apps, contents, and other products and services such as iCloud, Google Drive. And they just state that whenever you use a third-party service, you want to make sure that you comply with third-party services terms and policies. But they don't really talk about, you know, making sure that that they are not liable for any third parties services. They don't really talk about how they want to control or make sure that it's separate from their business. So that's where they're slightly different, and they maybe make it a bit more user very friendly to read in that sense. Then you have the section on licenses here. If you look at this particular clause, this is essentially what we talked about ownership of IP, intellectual property. So WhatsApp says here that we own all copyrights, trademarks, domains, logos, so on and so forth associated with our services. So this is essentially making sure that they let users know that this is our IP and you do not have permission to use it except based on our consent. Then you also have another clause here, which is WhatsApp's license to you, the user. So WhatsApp actually grants a license to the user, which is limited, revocable, non-exclusive, non-sublicensable, so on and so forth. And this, if you read this line, this is very important. This license is for the sole purpose of enabling you to use our services in the manner permitted by our terms. So this is really limiting WhatsApp's technology or their license to you and how you can use it. So these are things you want to always have in your terms of use. And then disclaimers, you'll see, I'm not sure why a lot of disclaimers tend to be, you know, capital font and stuff, but I guess it's to let you know that like this is the most important clause in this terms of use. But you know, it will generally just say that you use our services at our own risk on an as-is basis, and it would state certain warranties, state that, you know, we do not make any warranties on the fitness of our technology, that it's free from computer viruses, and so on and so forth. You will also see here that they have, sorry, okay. So you also see here that we will have a limitation of liability clause, which is, if you take a read here, it says WhatsApp parties will not be liable to you for any lost profits, so on and so forth. And the aggregate liability would be $100 or any amount that you've paid us in the last 12 months. So, I mean, if you guys use WhatsApp, you know that you don't pay anything for it except giving out data. So essentially, that means that any liability that they have that they owe to us would be $0. So this is the way you can sort of limit your liability in your business terms and services. So the last one is an indemnification clause where, sorry, this is not the last one, but you can state something along the lines that says you agree to defend, indemnify, or hold harmless. So you get the users to indemnify WhatsApp from any liabilities relating to the access or use of the services, any breach of the terms of use, and any misrepresentations made by you. So what is the difference between this indemnification clause and this limitation of liability? Because I mean, they both relate to liability, right? So limitation of liability is more about who will be liable for the loss and up to how much. So you always have this like a monetary amount, and it's limited to that. Indemnity clause is more about who will bear the cost in certain situations, and it's more on a reimbursement basis. So you would have to pay out of pocket. Okay, just down to the last three points I'd like to bring up. So if you see for WhatsApp, they use the laws of state of California, and they've decided to use either court or arbitration, two different dispute resolution mechanisms. Arbitration generally allows you to settle a dispute confidentially without having to go to court, but that really depends from country to country and what are the rules that apply there. Then you also can have a termination clause such as this, which basically allows WhatsApp to terminate its services with users if they have violated the letter or spirit of the terms. And the last one here is they have this clause essentially that says that WhatsApp can can amend or update their terms from time to time, and you will see the updated version in the last modified date. We saw this at the start of this document. And your continued use of our services confirms your acceptance of your our terms. So here, generally just using the terms, sorry, generally just using the WhatsApp itself, you would be agreeing to the revised terms that will change from time to time. And I think so that's about it for the WhatsApp's terms. I will now go back to the presentation. Okay, so going back to the presentation itself, I'd just like to conclude now. So I'd like to just emphasize these two main points. Preparing a terms of use is not entirely an easy task because if you realize it's actually a contract, just like your distribution agreement, just like your manufacturing agreements, this is pretty much a contract. And it needs to be customized based on your business model, the types of products or services that you offer on your app or website, and the types of customers that or users that you deal with. So here I'd like to point out that it's important to, while it's easy to, like just copy wholesale from WhatsApp, Uber, if you just go online, you will see a lot of terms of use, terms of service that you can take from. But the thing is, these are all customized based on their business models. So you want to maybe reach out to your legal advisors to review your policy if you draft any, just to see that it's on track and in line with your business model. I also like to just emphasize that it's not just important to have a terms of use in your website or app, but make sure that it's legally binding and enforceable on users. Because in the end of the day, if you have a terms of use that was not accepted or agreed by a user, then you might have essentially created a document that is not legally binding on a user. So you want to think about the click I accept concept and see how, and that's basically called a click wrap agreement or so. And that's how you want to try to make sure that it's enforceable. So these are the two things that I'd like to, emphasize today. Yeah, and now I think we have a bit of time for Q&A.
Thank you so much, Dashita. I think all of us can attest to the fact that you really made it very simple for everyone to understand, even those like myself without a legal degree. And we have a bunch of questions, and I think they're very pertinent ones. Well, I'll start off the whole question Q&A with my own question. I think it also answers one or two of the questions that a few of the women-owned businesses have asked. So, for example, you mentioned at the start of the presentation that you can use the terms of use to cover, like use of logos and something like this. And what if the logo is not trademarked? Can your terms of use still be legally actionable, even if it's not trademarked? Because is trademarking a separate legal process in itself?
Right. Trademark, yes. So you need to register your trademark generally to make sure that it's protected in the countries that you want to have it protected. But generally also having this in your terms of use in itself gives some level of protection. So you can specify like these logos on your document. So even in your terms of use, you can even put like the logo and so on to just specify like these are my marks and these belong, or whatever that you see on the website, these marks and these logos belong to me and you're not allowed to use them. So it's a form of protection. And it just gives you that level of, but if you want obviously the higher level of protection, then you want to make sure that you get that registered in the countries so that no one can really copy it. But you at least have this document, and then you will have a contractual right against the person who has copied your logo. But so for example, if a user has actually visited your website and copied this logo, and you can actually link it back to this user who copied it from you, then maybe there's a way to enforce a contractual action against that person.
Thank you. As I continue to ask more questions on behalf of everyone, I'm going to conduct a poll, which is part of our reporting. So I appreciate if everyone could just, while you listen in, to complete this little poll. It's just 3 short questions. Next question, and I think it's everyone can, we have experience with this. Why is the terms of use usually in very tiny fine print?
That's the lawyers doing. They're such naughty people. No, I think, the idea, I think, to me, I feel that terms of use should be this huge document that you see in front of anything that you want to, before you want to access a website or an app. You see that and you are forced to, get rid of it by clicking accept. But why it's made, very small or the sort of fine print is just because they want, it's probably a better user experience in the end, but they're not allowed to make it too small a fine print, which is why in the end, when you do register for something, you still need to have this click wrap concept, which is that you need to click that you accept to these terms, and they would probably try to make sure that they've hyperlinked the relevant documents that you need to read before you accept. And that's where, you have it in your face that you have to, read these documents, click on the link and stuff like that. So it's not that they can't do it, but there is, in certain countries, there are laws that prevent you from making it too small a fine print. Yeah.
Thank you, Dash. I'll ask a couple more general questions before we move on to more sector-specific ones. So this one is, it's related to the previous question. What is the maximum or minimum number of pages our conditions or terms of use could be?
There is no maximum or minimum, actually. If you would come across actually certain websites, like if you go on Google's terms, right, it's pretty cool. It's like almost images with like a few words, but it's long, but it's just images and a few words. So you can draft it in any way you want to make it as user-friendly as possible. Like if you look at WhatsApp, it's quite user-friendly because it's not just this whole bunch of like words and long documents, but you can actually read them and it makes it clear. So no minimum or maximum number of pages. As long as you have the right content in there, then you probably have a good terms of use.
Great. Another one. Okay. Let's go to the more sector specific questions. So this is a company, is a tour operator in the tourism industry. Do we need to put terms of service on our website? Will it not dissuade people from accessing our website for information? So I think these are two questions, right? One which is you kind of answered before about dissuading people with the web terms of use, and so I'll direct this person to the earlier part of the presentation. But maybe for a tour operator, for example, is it a necessary thing to have it on their website?
Yeah,
If you,
so sorry,
please
carry on.
continue, sorry. Oh,
Sorry?
please continue, Dashita.
Okay. So generally, if you have a business, any type of business that has a website, always try to have a terms of use on your website, because it would govern how you would like to present the information, what people can use this, your tour. For example, on your tour operator website, you may probably put packages that people can buy off, or information about your contact list, or anything of that sort. So you want to be able to make sure that people know that how they can access your website, what they can do, what are the refund policies that are in place, how they can purchase a package, so on and so forth. So it doesn't really dissuade people, because you can do it like, I think if you saw in the earlier slides, somewhere here, which is almost just a general website, you would see that they just have it at the bottom here, right? So that's good enough in a way, and doesn't dissuade. The only ones that I would really recommend to have this click I accept concept is specifically where you are getting people to register a profile on your website, or if you have an app and you want to, basically onboard someone, then that's where you want to make sure that you have this click I accept concept. But generally, you can just have it at the bottom of your website for general websites. I hope that answers.
So, for example, I will ask them for a few more follow-up on questions.
Okay.
For example, you have one for the website terms of use or the app, but let's say you decide to purchase a particular tour package from a company. Do you need a second set of terms, or a click wrap, or I accept component when they decide to pay, or can that all be integrated in one terms of use? And
yeah, so so you'd see there's two separate things, right? So terms of use is just how you would use your website, and you can then have a separate terms of and conditions, which is what I'll cover in the next 2 weeks, right? That will govern how basically the deal of like buying a package, what needs to be covered in terms of like refund policies, how you can buy a package, so on and so forth. So you can have that in your terms and conditions. But your terms of use is more of how you can access the website and all these services. So you can also look at them as two separate documents, two separate legal documents, or you can actually combine them as well and make it like one huge long document that covers everything. So it's just about style and structure of how you want to do it, I guess. Yeah.
thank you, Dashita. Let me move on to the agribusiness sector. So, all right. So this person is from the agribusiness, of course, and came across a website with some pictures and videos that this person particularly likes. So can this person use some of the pictures and videos without looking like they're stealing?
Well, anything that we copy from a website, when we download pictures or anything, that's in itself, in a way, we are copying, or not allowed to do that because it's their copyright, especially if it's their pictures and stuff. So I would recommend you don't do that, I suppose. Yeah, I hope that answers.
Thank you. Yes, I would also recommend this person to, when you go on Google and you search for images, you can actually select the kind of property that this picture would have. Some are free for everyone to use. So those you can use, reproduce, or with modifications with no, legal consequences, whereas others are, intellectual properties of others. And the next question would be in fashion industry. So how do we get templates for terms of use for my industry? And how do we legally do that? Do we need to create a link or URL
So it's a couple of components here. So how we begin with how do we get templates for terms of use of fashion industries? Can I go on to other brands, big brands, and then just look at terms of use and try to copy and modify?
Yeah, I would suggest that because that's like, go to one of the bigger brands that definitely have like, great lawyers behind doing all the work. So, go to one of the bigger brands and, you can try to see how they've drafted it, and then you can modify it based, if you follow that particular type of business model, you can try amend it, but obviously don't copy wholesale because that's their copyright. So you want to make sure that you change it and amend it, but you can use that as a guideline to follow. Yeah.
Perfect. We have a couple more, if you don't mind, Dashita.
Yeah, sure.
I think this is the interesting part where, we start to apply what you taught us to their own business experience. So, all right. Okay, this is for, I believe it's an IT company. So if I create a website for a client, who pays for the lawyer? Is it me or the client?
Can you repeat that question again?
If I create a website for a client,
yeah,
who pays for the lawyer to, for example, in this context, to create all these terms and policies?
Oh, yeah. So usually it's the lawyers that do it. If you're using, like a WordPress or, one of these Wix or any of these available website developers, right? They don't really provide you these documents or like these terms of use and so on and so forth. So you can create it by working with lawyers, or you can try to work on a first draft by looking at something like I just mentioned earlier, like a particular business that already has it, and then you can tweak it and maybe see your legal advisors to review it in the end to see if everything flows nicely.
But what if it is your client who wants you to create a website, and who is the one that's going to hire a lawyer or to create this terms of use, and who should bear the cost of this?
Yeah, so legal document, like if your business is to develop websites, then
follow them now. I mean, I want to sit down.
Oops, sorry. Hold on, please.
Please, no, sit down there.
I'll have to mute everyone. I apologize. To not interrupt.
That's your good number, no, sit down here,
All right, here we go. Yes, Dashita. Could you please answer again, if you don't mind?
Yeah, so if you are developing a website, then if your business is to develop websites, then that's not your job to create the documentation behind for the website, which is the terms of use, your privacy policy and all that. That's on the business itself to do it. So they will have to reach out to their lawyers or whatever else and come up with these legal documentation. But
Great.
For this person who's doing it, then they can just value add by telling their client that hey, make sure that you have these documents, these policies in place, for just value add, and maybe they might be better for the client too as well.
Thank you. That's great to know. And okay, this is quite pertinent to everyone. So let's say, in your experience, how common is it for enterprises to have legal confrontations because they do not have a terms of use?
I would say it's more important for, not so much for like generic websites that just have, like for example, this one, right? She has the terms of service, but as long as she has another terms of condition and she has like exchange and returns policy at the bottom, then the terms of use is not so important as long as you have other policies that govern it. But I would say it's very important for service providers. So if you have the Ubers of the world, the WhatsApps of the world, any of these kind of service providers, then you want to have terms of use to govern how you can protect your IP, how you can use these services. So terms of use is important, but not as important as the one I'm going to be covering in the next presentation. I can't really answer because it's quite a wide question, right? And it depends on your business model for me. So if I can understand your business model, then I can know whether this is very important. As long as you have these terms like disclaimers, of liability, indemnity clauses, you have some of these important protection of IP, licenses, then I think you are in a good place. Wherever
Okay.
yeah.
So I think this relates to this example that you're showing on your screen, right? Is it binding if it is displayed at the bottom of the page you showed, right? And if the user didn't read or click I accept, is it legally binding?
So there's quite a lot of cases on this, and it sort of differs from like country to country. Generally, if it's just at the bottom like this, and the user didn't click I accept, right? It is still binding, but it's not as strong or as enforceable. Like there might be cases that maybe in your support, if you're a user, to say like, hey, I didn't read this, I didn't agree to this, as compared to a click accept concept. But this is still, yes, binding, because in the end, if you see the way in which your terms of use are drafted, the first clause will always say that as long as you're using our services, you agree to this.
Okay.
So as long as you have, if you have any customer onboarding processes, you can always put in this click I accept concept.
Okay, and I think this relates to a subsequent webinar that we will have. What is the difference between a privacy policy and terms of use?
So a privacy policy governs more on data protection. So I'm not sure if you guys might have heard about like the GDPR laws, quite a few data protection laws and privacy laws that are coming up. And basically, because now data is oil, right? The new form of oil. So when you use WhatsApp, why you don't have to pay for it is because you are giving data to WhatsApp. So a privacy policy would govern how is a user's data used by the company, by WhatsApp. But in terms of use is more on how you can use the app. So that's quite different in essence.
Okay, and I do have a question about, all right, this one. For dispute resolutions, what should be the country or place for resolution and the type of applicable law that one should put in the terms and conditions?
Okay, Doris, depends on where you are from, I guess. So if your business is located in Ghana, for example, then you want to make sure that your dispute resolution, the country or the applicable law would be the law of Ghana, for example. But if your business a bit more is not just located in one country, but it's really a global sense, then you want to probably focus your law still in Ghana, but the dispute resolution, which is which mechanism, right? Would it be the courts of Ghana or arbitration? That can change because sometimes you want to choose a third party location to resolve disputes, especially where you have users from, say, UK, US, then you want to choose a middle point to resolve disputes. So it really differs. I think I need to know a bit more information on the business model and where they're located for me to be able to answer this, I guess.
So I have another issue which we sometimes hear from women in the fashion industry where other competitors copy the designs. So is this something that they could, include in terms of use to protect the design, the intellectual property, or are we getting ahead of what you'll be covering?
Yes, you can put it in your terms of use, but the problem is trying to enforce it, right? In the end of the day, how do you know that that person has stolen design? Except if you can somehow link the IP address of the person visiting your website, and you're able to identify that this thing was downloaded, some images were downloaded or some content was taken, which is why a lot of time you see this happen anyway, that information gets stolen or so. But the idea of having that in your terms of use is just to make it very clear to everyone that as long as you visit my website, these are my rules and these are my IPs and this is what I'm trying to protect. Yeah.
I would like to invite maybe two last questions, and because Dashita has mentioned terms of use is particularly important for companies in the services sector like IT, tourism. So if you do have any questions relating to that, I think that's particularly important to you. Do you have any more questions from the tourism and IT companies? If you would like to pose a question and speak to her directly, you could. I'll just open the floor for the next 15 seconds. Any more questions? We will be sharing the recorded version of this, and important note is that Dashita has showed examples on her slides as well as the WhatsApp terms of use. Do not copy freely because that might not apply to your company. That's why she has advised that you have a legal advisor, a lawyer to help you with that. So don't copy wholesale, and if not, some might be legally actionable. I'm not entirely sure, but Dashita can advise. Okay, Virginia has a question. All these are put on the website. Since they are not sworn to the courts, are they binding?
Sworn into by the courts. So I mean, generally your contracts, I'm not sure about your particular laws, your country, Virginia, but at least from where I am, which is Singapore, you don't need contracts to be sworn in to the court. So generally, as long as you meet these elements where you've offered, you have both parties have signed the contract. I mean, this is for like a physical contract, right? So parties have signed the contract, there's consideration given, and nobody was forced into the contract, and everybody has intention to create legal relations, then you have created a contract. And in this case, with terms of use and all these things that are put on the website, the way in which it's drafted gives users or gives the company some sort of right to make this binding by way of making sure that you make sure that they accept or read these terms of use before they use the website and stuff like that.
Great. I will take two last questions. One is from Rachel Duke and one is from Bosun. So Rachel, if I'm going to rephrase your question, if I am a lawyer by profession, can I stand in for myself? If I've misinterpreted this, please, Rachel, unmute yourself and speak. Yes, so that's the question. If I'm a lawyer by profession, can I stand in for myself?
Stand in in what sense? Is it in court?
Yeah, Rachel, would you like to unmute? Let me see if I have to unmute you. Would you like to pose the question and give more and elaborate? You're unmuted now, so you can speak, Rachel.
Okay. So I wanted to find out, since you said you need to get a lawyer while writing your policies, your terms of condition, I want to find out if I'm a lawyer by profession, can I, stand in for myself, like all of those processes? I can be the lawyer and be the website creator myself. How about that?
You can be the website creator and draft your own. You want to draft your own terms of use, is it?
Yes, and then as a lawyer by profession, can I also sign on behalf of the content I have created?
What is your business creating terms of use, or is your business something else altogether?
Sorry, I didn't get that.
Is your business being a lawyer by profession? Is it?
No. We're talking about creating a website and then the conditions, the terms and policies associated with it. I need to get a lawyer. I'm not asking if I'm a lawyer myself and I'm still creating the sites. What happens?
If you're a lawyer yourself and you're creating, so your business is to create websites, is it? Can I understand this correctly? Or is it your business is to create terms of use?
Website creation, web design.
Yeah, so you're doing web design, right? So you're developing websites.
Yes.
And then
and I'm creating a website for a client. And so you're saying that we need to get a lawyer to solidify the creation of that website. And then I'll ask, if I'm a lawyer, can I still stand in for myself, like be a lawyer and then sign my conditions and terms?
Yeah, so if your business is to create a website or design a website, then that's different from coming up with this legal documentation, right? Because terms of use, terms and condition, these are all legal documentation that usually a lawyer does it. So if you're a lawyer by profession and you can draft these, then you can, for sure, go ahead and draft it and include them together with the website. But in the end, I think you need to be, because I believe if your job is to create a website for other clients, then you want to be able to make sure that you draft the terms of use well enough for them to be able to, for it to work for their business model. So that works. But I think, yeah, if you're a lawyer by profession and you know how to do this, then why not, right?
Thank you, Rachel, for your question. Let's take one more. And Virginia, Dashita has answered your question, so I would ask that you revisit the recorded webinar. We have one last question from Bosun. Well, thank you for the excellent delivery, and I think the same. I constructed my website using WordPress, and it has terms of use as part of the tools. Is it detailed enough?
So I think WordPress probably would give the standard terms of use, just like this one, which is done by Shopify. They probably give you a standard terms of use that you can use. But obviously, I think here you want to consider what we've just discussed, all these different points. Think about whether this terms of use has covered it and whether it's covered it enough for your business model. Then, check and see. So I think the best first step, go to, choose a terms of use that already that you've seen on other business models that are similar to yours, and then check and see if there's anything you've missed out, and you can then work on it and draft accordingly. Yeah.
Okay, I said it was the last question, but okay, this is the last one. I'm so sorry. Opilua from Nigeria, would you like to post? I'm going to unmute you, and this is the last question we'll take. Could you speak, please?
Yes, thank you, Edson, and sorry for diving in at the last moment. In Nigeria, we have a lot of different kinds of lawyers. However, we have very limited specialized lawyers in terms of e-businesses, IT, and drafting contracts. What can we look out for in deciding as an IT company this is the best lawyer to partner with, because we have a very limited pool, and sometimes you have a lawyer that's more into drafting agreements for say, real estate, or somebody that is into charge and bill or addressing criminal cases, and those are the ones that are pretty common. How can you find someone what are the things to look out for to know this is a lawyer that understands e-business and can also help you draft this as someone who is not in the legal business? Thank you.
Yeah, so I think the first step is a corporate lawyer, because these are all corporate documents, right? Like your general distribution agreement, manufacturing agreement, any software licensing agreements. So you're looking at a corporate lawyer, not a criminal lawyer, not someone who goes to court, someone who's really just at a desk all day or something. But the idea is corporate lawyer, and then you want to look for someone who's, maybe you want to ask the lawyer if they've experienced drafting, privacy policies, terms of use, whether they've drafted software agreements. So you can sort of like ask them or test them on the clients that they've worked with in this industry. So then you can get a better understanding of whether they've done this kind of work and whether they will be able to deliver. So that would be a good way to do it.
Does that answer your question, Opilua?
Yeah, it does. At least I can streamline it to looking for corporate lawyers who don't go to court, and then from there I'll probably have to look for references from other e-businesses that have tried them before. Thank you. So yeah, it does.
Pretty much.
So great, fantastic. This has been a fantastic session. I think one of the most engaging ones I've had this year. So we will have 2 more, and hopefully, of course, fingers crossed, there will be more sessions to come after this too. But I think this has been very applicable to everyone, and please, attend the following 2 sessions to make sure you have a very good picture of terms of conditions, and that is what we cover next: terms of conditions, privacy policies, and protecting intellectual property. We must thank Dashita for her time. It's quite late in Singapore, and I'm also wishing everyone happy Eid Mubarak, and have a great weekend, everyone. Thank you, Dashita, again.
No problem.
And I wish everyone a great weekend.
I enjoyed it, and yeah, if you have any questions, we can continue to discuss it in the next session, and anything that comes up along the way. If you have any questions, you can post them to I guess to Edison. I'm not sure.
Yes, please. If these are questions relating to intellectual property or terms and conditions, privacy policies, I would ask that you reserve them for the next session. If you'd like to ask specific questions in terms of use, you should have my email address because you've been receiving a lot of emails from me. So send them my way. I'll try to collate them. And yeah, so thank you everyone. Eid Mubarak again, and have a great rest. And stay safe, of course. Thank you.